Almost afternoon. I could say good afternoon, as a matter of fact. But we're going to take the 2 minutes to start early. I'll use that time to just introduce myself and to introduce the team. I want to just very briefly express my own pleasure at how things have started at this event, and indeed the collaboration that has started between the Mona School, the University of the West Indies, and the Industrial Disputes Tribunal. It is, as one would say, it's an idea whose time has come. Came a long time, but I would say that, my grandmother would say that nothing happens before the time. And we are pleased that this now is beginning to take shape, very optimistic and about the possibilities, and very happy at the level of endorsement that we're seeing in various quarters. And I think it speaks, as I've said to others, it speaks to the quality of the leadership, both at the level of the Industrial Disputes Tribunal and the level of the Ministry of Labor. This tradition of collaboration between academia and the field of industrial relations or employment relations or workplace relations, whatever you choose to call it, is a time-honored tradition. Industrial relations really is not an academic discipline, has never been an academic discipline, purely an academic discipline. So the fact that this is happening is great. I'm the chairman for the symposium, but that's a very easy job. I'm really just here to introduce the chairs of each of the sessions, and they will take charge of the event. So I'm going to stop speaking as of now. As you notice, we have three different themes and three different sessions. And the chairman for this first session is Mr. John Paul Watson, who is an Assistant Attorney General and who works at the Ministry of Labor and Social Security. We have, in each of those sessions, we had planned for 4 people. Dr. Orville Taylor, who was committed and is still committed to attending and participating in this activity. I'm not sure he's going to be able to reach on time. He has already sent his apology, and he has spoken to one of his colleagues who may include some of his remarks in her comment. So I'm just now going to ask Mr. Watson to please come to the podium and take charge. Now, let me say this. Come, Mr. John Paul. Clap him by all means. I'm sorry I interrupted you. So we have roughly an hour and a half. And we hope that your parties can allow some time. So you will encourage them, and we will try to manage that for some comments from the audience. Comments as well as questions. All right?
Hi, good afternoon, everyone. A warm welcome from the Ministry of Labor and Social Security. Today, I have the honor of chairing the panel discussion on the theme Amendments to the LRIDA and the Labor Relations Code, Balancing Fairness and Equity. As we begin this discussion, it is important to recognize that industrial relations systems play a critical role in fostering stable and productive labor markets. These systems establish a framework of rules that seek to balance economic efficiency with employment relationships and interactions amongst the tripartite, which is the government, workers, and employers. As global labor standards continue to evolve and as the world of work changes, it becomes increasingly necessary for countries to periodically review their legislative frameworks. Such reviews are important to strengthen the protection of workers' rights while acknowledging the realities and challenges that are faced by businesses. Here in Jamaica, the Labor Relations Code, its attendant the Labor Relations and Industrial Disputes Act, its attendant regulations, and the Labor Relations Code have been instrumental in shaping our labor relations landscape since their introduction in the 1970s. Over the year, the Labor Relations and Industrial Disputes Act has undergone several amendments, namely in 1978, 1983, 2002, 2010, and 2014. Among these amendments, perhaps one of the most significant changes came in 2002 with the amendment of the definition of the term worker in the legislation. Equally notable and perhaps a bit more controversial at the time, and some would argue still a bit controversial based off of developments, was the 2010 amendment that enabled non-unionized workers to access the Industrial Disputes Tribunal, which I'm pretty sure will form part of the discussions today. However, notably, despite these amendments, the Labor Relations Code, often referred to many as the Little Blue Book, mostly laypersons, and regarded as the Bible sometimes in industrial relations atmosphere, has remained unchanged since its inception in 1976, which is some food for thought. The absence of amendments has created a situation where questions are now being raised regarding the code's applicability to individual workers. Additionally, it has generated concern among several stakeholders who have openly challenged the manner in which the Industrial Disputes Tribunal applies the code to non-unionized workers, and in particular, those employed by small and medium-sized enterprises as well as individuals. Considering these developments, there are some very important questions that would naturally arise. For one, where does the arguable piecemeal approach legislative amendments to the Labor Relations and Industrial Disputes Act and Labor Relations Code leave us as a country? Does the Labor Relations and Industrial Disputes Act and the Code in their present form adequately meet the needs of our society, particularly in light of the constant evolution of work and changes within the industrial relations landscape? And ultimately, does the current framework of the Labor Relations and Industrial Disputes Act and the Code enable the Industrial Disputes Tribunal to effectively fulfill its mandate of arbitrating and settling industrial disputes in a manner that is fair and equitable? To answer these questions, one perspective is that we must begin with a comprehensive assessment of a legislative framework governing industrial relations, something which the ministry is currently undertaking. Such an assessment would help to identify legislative gaps that may prevent our nation from having an effective industrial relations system. Importantly, that assessment could also inform proposed amendments to the Labor Relations and Industrial Disputes Act, its attendant regulations, and the Labor Relations Code, which forms the primary focus of our discussion today. Without ado, I will now introduce our distinguished panelists. I'll start with a man who should be no stranger to anyone or most of us here. So contributing today to this discussion is Senator Lambert Brown, who has been serving as a senator since 2012. He is a well-known trade unionist, the president of the University and Allied Workers Union with over 50 years of labor advocacy, and has been a key figure in the Jamaica Confederation of Trade Union. Senator Brown has been awarded the Commander of the Order of Distinction in 2017 for his contribution to labor relations. Oh, my apologies, Senator, 2012. He is known for his advocacy for workers' rights and has been involved in various public sector boards and has contributed highly in the media as it relates to labor rights. Senator Brown's commitment to the public service and labor rights has made him a respected voice in Jamaica. I will move on to our second panelist. We have Mr. Errol Miller, who is a distinguished... Oh, my apologies. Can you give Senator Brown a round of applause? And then move on to our second panelist, Mr. Errol Miller, who is a distinguished professional with 43 years career experience in the civil service since 1972. He built his career upon a solid academic foundation in management studies, human resource management, and industrial relations. Throughout his tenure, he held several significant roles, including serving as workers' representatives and government principal negotiator for public sector wage contracts at the Ministry of Finance and the Public Service. He also spent several years as a senior conciliator at the Ministry of Labor and Social Security. Through leadership and continuous professional development at both local and international institutions, he eventually rose to the rank of Chief Technical Director before his retirement. Since September 2020, Mr. Miller has continued his public service as Chairman of the Industrial Disputes Tribunal, where he leverages his extensive management and labor relations background to oversee fair resolution for all parties involved. His commitment to good governance extends to other organizations, most notably the Jamaica Civil Service Mutual Thrift Society, where he has served as chairman for the past 14 years. A round of applause for Mr. Miller. Last but not least, the older lady on our panel today, Mrs. Carla Ann Harris Roper, who I do know quite well. She actually introduced me. She was actually part of the interview panel that first got me hired at the Ministry of Labor. I will never forget because she asked me some questions and I was like, boy, this interview not going well at all. Ms. Harris Roper is, my apologies. Mrs. Carla Ann Harris Roper is a distinguished attorney at law and labor relations specialist with extensive experience across the public, corporate, and legal sectors throughout the Caribbean. She holds a Bachelor of Laws degree from the University of the West Indies, a legal education certificate from Norman Manley Law School, and a Master of Laws in Employment Law with distinction from the University of East Anglia in the United Kingdom, where she was a Chevening Scholar. Throughout her career, she has held several legal positions, notably one as a senior or the head of the Ministry of Labor and Social Security's legal department. She also served at the Ministry of Justice, and she then went on, or you can correct me if I'm wrong, to be the Regional Director of Labor Relations for Scotiabank. Yes. Mrs. Harris Roper is also the co-author of the highly regarded publication Commonwealth Caribbean Employment and Labor Law, which we do rely on a lot at the ministry. And she currently leads her own legal and consultancy firm, Employment Matters Caribbean, where she provides expert guidance in employment and industrial relations matters across the region. Could we have a round of applause for Ms. Harris Roper? We were supposed to be joined by a fourth panelist, Dr. Orville Taylor. However, he was unable to attend, and he does send his sincerest apologies. And with that, we will commence our discussions first with Senator Brown.
Chairman, let me thank you. I'm told when we were first asked to make the presentation, we had 15 minutes each. I've since been told it has been cut to 10. That's fine with me, because on a Friday I can go elsewhere and talk a little longer. I want to start by recognizing John Jr. John, are you able to stand? Because, John, let it not be said that the work and effort of Michael Manley and you, Shira, was not responsible for this legislation, because it is the two of them in that parliament that got this legislation through, and we must recognize that. This morning as I listened, I heard 50 years, I heard it's a long time, it's a short time, and I have a good friend, you know, always believe that he's a good friend of mine, who said that some legislation has been around before he was born. So let me just deal with a piece of, again, let me get into some trouble. Because I'm not in parliament, I can quote another language here. Or the alterum partem. That's Latin. But John, isn't parliament allowed to speak Latin? but they can't speak Patois. All right, cool. Only English, not Latin. So let me start, because I've changed up this presentation a little. I want to go to 200 years of natural justice. May surprise some of you that my quotation is from John 7, verse 51. Nicodemus was defending Jesus against the high-priced lawyers of the day, the Sanhedrin. And Nicodemus asked the question, does our law judge a man without first giving him a hearing? That sounds to me like the altering partem. That's Latin for one of the first natural justice points. So, for 2,000 years, that right, which is now recognized at the IDT, has been around. Unfortunately, the laboring classes in Jamaica have not benefited for a long time prior to 1975, from that principle which is over 2,000 years old. It's working, yeah, over 2,000 years old. So what we're finding is that through slavery, slave trade, 1807, abolition, Amelioration Act, emancipation, the working class, the working people didn't have that equity that we now want to get going. And so, in 75, with the advent of the Labor Relation Industrial Dispute Act, the right to unfair dismissal came about. That discussion prior to that, it wasn't so. We had the post-emancipation Masters and Servants Act, 1848, thereabout, which Gavin lasted until 137 years after, to 1975. That was the law. So 50 years of, 1947 vacation leave. Yeah, it's just a baby to that Masters and Servants Act, whose mentality today, 50 years after its repeal, still govern much of the relationship in the workplace. And so I wish to say that what existed prior to 75, Mallock and Aberdeen, that an employer can fire a worker even if he does it unreasonably, capriciously, that dismissal would still be valid. And funnily, outside of the tribunal chairman, that law still applies in our courts. That is to say, the worker didn't have to get a hearing. No natural justice of 2,000 years ago would apply to the worker. And then they say, oh, Regent Baldwin did create a space for some of the workers, but the bulk of Jamaican workers were not provided with the protection that the unfair dismissal now provide to them from the 75 thing. And this is where I want to quickly get to the 76 discussion in the Parliament. Revision of the law. The law itself, the LRIDA, creates a provision for the revision of the code. And the code itself, at Section 4, speaks to the revision of the code. The code has not been revised since 76, for good reason. In the discussion in 76, our friend Carlyle Dunkley argued in the Senate that the revision was going to be imminent because of Rex Nettleford's worker participation report. But thankfully, there was no revision because no worker participation, what is that again? Not something that the modern society now recognizes as important as it is. And then Leon Osang says the revision should be frequent. He was speaking from the JLP, but he was involved in labor relations. And Ian Ramsey said, these were admirable aspirations. I think he got it right. But the quotation I want to share with you is from the former Minister of Labour, who said in 76, I've been through the code and I've found that it is a package of pure common sense. I paused there, only a man from St. Thomas could say that. And I feel that the opposition is in duty bound to support it for the reasons given. And then he went on, Mr. Speaker, that I will support the minister very strongly in saying the code on paper means nothing at all unless trade unions and employers' organizations or individual employers and individual work people themselves are prepared to work sincerely to let the code itself prove a success. My view is the code has proved not itself a success. There's no need for any changes in the code. I just encourage you to look at Sykes' judgment in the Jennings case, NCB Jennings case, coming from the IDT, where he outlined in that case some background issues, information, where he quoted extensively Rattray, president of the court, in the Village Resort case. So for ease of time, I ask you to go and read Sykes, NCB versus Jennings Supreme Court. With that, I am of the view no changes are needed to the code. Are there changes needed to the law? Yes, I want to just put 4 changes that I believe are needed. 1, contract work need to be treated as indefinite employment. The approach taken in the Tobago House of Assembly case that the High Commissioner who's here presided in the Trinidad court is a good model for us to follow, and of course other countries have followed that model. A law that I detest a lot, Gavin, is Addis versus Gramophone. That's 1909, 50 odd years almost before I was born. And I'm a little bit older than you. Right? In Addis, it says, the feelings and the way you fire somebody don't really matter. So you call somebody in at 4 o'clock on a Friday and say, you know, we're making it redundant, no consultation, all of that, and you probably tell a little lie, damage reputation, and our system says you can't give that worker, Addis says you can't give that worker any compensation for that. That need to change. The courts of appeal dealt with it in the Marilyn Hamilton case, but I feel legislation need to come to give it. Interestingly, this morning a lawyer sent me a case out of New Zealand, where the New Zealand tribunal was able to give compensation for hurt feelings. We need to move in that direction. Third one I believe need to be changed is the award of interest. Now, the Supreme Court awards interest in cases. I did a case, the famous UTEC case. The company went for judicial review. Judge ruled in the Supreme Court against the tribunal. The lawyer, I won't call his or her name, went to the Supreme Court and asked that the worker must pay back the money and that she was paid on her reinstatement with interest. And Justice Mangatal awarded interest, that the worker paid back with interest, but she didn't get any of her money with interest. I believe that workers should be able to get interest on the awards of the IDT, and that's a legislative change that is necessary. And if you doubt why that is equity, look at the private power case, 2013 award of the IDT. The matter ended at the Privy Council in 2025. And the money that the workers are to get is the 2013 money without interest. That needs to be changed. And the last one I wish to advance before I pack up is that a worker is awarded. I have 2 minutes, great. I'm going to be like Dwight Richards. All right, just take this into account. Margaret Curtis case, dismissed in 2018. matters going through the court. Constitutional court about the constitutionality of the tribunal. And the company has lost about 6 or 7 efforts in court. She haven't gotten her money yet. And so, but when she gets it, the tax department is going to treat it as if this is her salary for a single year, and no regard would be paid to it. But if she was down in King Street and she got a judgment from the court in King Street, they wouldn't tax it. And so I'm asking that we put in the legislation, in the amendment to the LRIDA, that awards of the IDT be treated no differently for taxation than awards of the courts. And I make those 4 suggestions because I believe equity has to be seen, Trevor, in a sense, in the historical materialism sense, right? In other words, we must see it from the background of history. The equity of the past has been $20 million to the slave owners and the emancipation of slaves. That was equity. Equity today must be that we protect and advance the cause of the workers rather than trying to balance it for the employers. They, I'm sure, some of you will agree, have the route of judicial review where in our system that could take you from 2013 to 2025. I just want to thank you. And thank you all that are prepared to answer the questions when the time comes. Trevor, just one other thing, just allow me to say this. When this law was being passed, and Kelly, if I mentioned your little babies, because I knew when you're trying to feel, right? No, but when this law was being proposed in 74, 75, some of us were opposed to the legislation. And Trevor, we put out a pamphlet way back then entitled The Labor Relation and Industrial Dispute Act, a dagger at the heart of the workers. Today I'm defending the act.
I want to thank Senator Brown for his presentation. Well received, contained a lot of historical information and relevant information for today. And the topic of discussion, we're going to now move on to Mr. Miller.
Not seeing the presentation. Okay, very well. All right, ladies and gentlemen, I want to use a different method in this presentation because I want to set the stage of balancing fairness with equity in terms of how the tribunal is constituted and how it functions in a very concise way. And that you'll observe from the framers of the law that they took into account this issue of balancing fairness with equity. So in terms of its composition, first of all, the law under Section 7 provides that there shall be established for the purpose of this act a tribunal called the Industrial Disputes Tribunal. That is what has established the institution that we are today celebrating 50 years of its existence. And the law further speaks to its composition and operation as set out in sections 8 and 10, as well as the second schedule of the Act. In the second schedule, it says that the tribunal shall consist of a chairman and not less than 2 deputy chairmen, all of whom shall be appointed by the minister after consultation with organizations representing employers and organizations representing workers, and shall be persons appearing to the minister who have sufficient knowledge of or experience in relation to labor relations. So you can see from the outset that there was a balanced approach of ensuring that both the employer, the worker, and in fact, a neutral person would have been hearing the issues. And those persons would have been persons who are familiar with labor relations. Of course, I just spoke to the chairman, but there are other members of that tripartite panel. And so the law provides also that not less than 2 members appointed from a panel supplied to him by organizations representing employers, and an equal number of persons appointed by him from a panel supplied to him by organizations representing workers. So each panel consists of a chairman, a person appointed from a panel supplied by the employer's organization, and from a panel supplied by the workers' organization. And of course, Section 10 speaks to special members, which I won't go much into, but the law provides the minister with the opportunity to appoint special tribunals for public interest matters. And in the interest of time, I'll just skip over that one. And that appointment is similar in some respects to what happens for the General Tribunal, except that it will be a special tribunal that will hear these matters. Now, Section 8 speaks to how the tribunal is constituted, and it says it shall sit in such number of divisions as may from time to time be necessary. So each division, as I said before, is chaired by a chairman or a deputy chairman, and was 1 member from the employer's list that has been supplied to the minister, and 1 from the workers' list. And each division, well, currently we have 5 divisions, 4 in Kingston and 1 in Montego Bay. And each division is supported by an assistant secretary, similar to what happens in the courts, like a clerk of courts, who provide the tribunal with that support. And of course, the tribunal's administrative functions are carried out by a secretary director. And all of these members of staff are members of the Ministry of Labor staff. The industrial disputes are referred to the tribunal by the minister under specific sections of the law. And what empowers the tribunal to sit is what is called a terms of reference. If we do not have a terms of reference, or if that terms of reference is not agreed by the parties, we are unable to proceed with the matter. Now, Section 8.4 is very important because where a panel has been appointed to deal the matter, and the panel is dealing with that matter, and 1 member leaves, whether by death, by resignation, or is incapacitated, that panel has to seek the acquiescence of the parties to continue with the proceedings, having had a substitute member appointed. However, if 2 members leaves the panel has to compulsory start the proceedings all over. In the first case, the parties can disagree to have the panel continue. They may say, we want a new panel or the new panel to hear the matter all over again. And there was a particular case I recall where the award was written, 1 member became ill, he was in hospital, the efforts were made to have him sign the award, the doctors refused to have it done, and so that award had to be abandoned, and the proceedings has to start all over. So that is what Section 8.4 provides, that in a case where 1 member leaves, there are some procedures that are necessary. Section 812 speaks to the fact that the tribunal should hand down its decision in 21 days. But it goes on to say, if that is not practical, then where it is impracticable, as soon as it is practicable. The current situation is that it's not practical to have an award in 21 days. In the first place, briefs are not even submitted, although requested, in 21 days. And in a number of cases, the sittings take a very long time to conclude. Currently, I have a matter that has gone to 50-odd sittings. It would have been possible to hand down that award in 21 days. And Section 12.1 also speaks to the fact that a copy of the award should be provided to all parties to the dispute, as well as to the minister. Paragraph 4 of that section speaks to the fact that an award in respect of an industrial dispute may be made with retrospective effect, but it can't be earlier than the dispute first arose. So it can go to the date that the dispute arose or some subsequent date. And it shall specify the date from which that award is made, and that the award shall be final and conclusive, and no proceedings shall be brought in any court to impeach the validity thereof, except on a point of law. And very often we have awards that have been challenged on legal points in the courts. And as Senator Brown mentioned, those can take you way up to the Privy Council. Section 12.10 speaks to the interpretation of award. So from time to time, awards may be made and parties may have a difficulty in maybe the language, and so they may seek an interpretation of those awards. Interestingly though, it's the same panel that made the award that has to interpret the award. And again, if one member who made the award is not with the tribunal for whatever reason, then we have a challenge. There can be no interpretation. From time to time, we have persons who are parties who will come to the tribunal and will set dates and they will not turn up. Now, this section 16A of the law gives the tribunal the power to hear matters ex parte. So if we have given reasonable notice and the parties do not turn up, we can hear one party and we can make an award based on that. Of course, the tribunal has the power to summon witnesses and to administer oath. And so if we are aware of issues that may be out there that people are reluctant to bring forward, we can summon parties to provide information. Because in the final analysis, the tribunal is a fact-finding institution. We are interested in the facts. And so we try to unearth all the facts in order to make the decision. And of course, very important section, that the tribunal is empowered to regulate its own procedures and proceedings as it sees fit. So from time to time, we hear people come and talk about what happens elsewhere. But we are empowered within reason to regulate our own proceedings and procedures. Now, there are some sections that I think that are maybe worthy of reform. I think section 8.4, the section about the de novo, might be worthy of looking at. Where 3 members constitute a panel. It may be something that we need to look at again when one party is no longer available. And as I indicated to you, the case where the award, where the matter went to the drafting of the award and was not able to be signed. It is something that maybe we need to find a a solution to. The Section 1210, I think it needs amendment, the practicality of 21 days after referral. I think that needs to be examined. I also think that Section 1210 regarding the interpretation of the award is something that maybe needs to be examined. I don't have the answer, but I hope that in these discussions, suggestions can be made. And from time to time, there has been the issue of whether the chairman of the tribunal, the criteria for the appointment of chairman need to be revisited. I think that we could have a discussion on that as well. Thank you very much.
Thank you, Mr. Miller. We will now invite Mrs. Roper to present.
So good afternoon, everybody. I am honored to be asked to be here, and my part of the presentation is to look at specifically amendments to the LRIDA. You would have heard also that Dr. Taylor is unfortunately not here, so I do have access to his presentation, so I will try to weave in some of what he has said in what we have. So I hope that buys me another couple of minutes. So, the 2010 amendment to the LRID, for many of us in this room, we have work because of the 2010 amendment. Let me talk it straight. We'll talk the things. And I can speak in somewhat of a bit of knowledge because I was the Director of Legal Services at the Ministry of Labor at the time when the 2010 amendment was enacted. The then Minister, Pernell Charles Sr., was insistent that he had to, make some moves towards changing what was effectively a wide swath of the Jamaican workforce not having access to the IDT, which was the only place that certain remedies could be found. So what you see on the screen is actually a representation of what the legislation looked like when G.G. Allen passed it. Signed it and brought it into operation. So where were we? Before 1975, when the act was passed, we had lots of labor aware, and know we have some people here who can speak definitively about that. Right, Prof? And so what we had then were two pieces of legislation, PUPSA, or Public Utilities Undertaking and Public Services Arbitration Law, called Essential Services Law. So anybody here talk about that is from before 1975. And the Trade Dispute Arbitration and Inquiry Law, or Trade Disputes Act. No. Essential Services Law dealt specifically with essential services. And the Trade Disputes Law facilitated voluntary mediation and conciliation of disputes in undertakings that were not essential services. And those legislations were built on very good intentions to try and bring order into the labor relations space and the economy at large. But they had certain legislative shortcomings. And soon we were able to see, or those persons, because I would have been about 2 years old, what was happening then. And enter, therefore, the Labor Relations and Industrial Disputes Act. It was interesting to me, who, a fan of history, just to read the Hansard of the discussions when the act was being passed. And if you really go back in history, a lot of the hard work, the heavy lifting in terms of the reviewing and the discussions and the meeting with stakeholders happened under JLP government. And then when the PNP government came in, this was one area that they found a chord. Everybody was singing from the same song sheet. So the LRIDA birthed the IDT, and the IDT, as we know, is a permanent statutory tribunal, unlike the ad hoc tribunals which existed under the previous legislation. And check this, the IDT was envisioned to provide quick, economical, third-party settlement dispute. What I say? Quick, economical, generally, and not only for essential services. And essentially it was, I heard it said in the early part of the 50 celebrations that the IDT was supposed to be the poor man's court. Anybody remember hearing that? Because it wasn't envisioned for nice lawyers like us to go and take up a residence. It was the areas for trade unionists and employers who had certain types of lawyers who were not so much steeped in law like they were in industrial relations. Your Bobby Boss, your former president of the Court of Appeal, that they sort of put aside their tight black and white legal hats and went to try and help settle a dispute. So the original iteration of the LRIDA was collective labor relations, because then, again, mega taught the things, we had much more union representation. We had more unions, more persons who were in unionized environments. Trade unions, bargaining units, all those provisions as to ensure that persons had the right to be a member of a trade union, had the right to be a part of a bargaining unit, and importantly, to promote industrial peace and dispute containment. So they didn't want wildcat strikes, they didn't want all these businesses to be coming to a standstill. The IDT and the LRIDA were brought into that. So access to the IDT was largely dependent on workers being members of trade unions having bargaining rights. That was your door. High Commissioner, what we call that now? The registered majority union. Recognized majority unions in Trinidad, because we have all of this happening across the region. Now, since 1975, I did some research, and we have had 5 amendments, and then we had what we call some consequential amendments. So the law itself was put before the court, before the parliament, but other legislation changed sections of the law. 1978, a big one, national interests. And the minister could then refer matters on his own initiative where it expected to be done expeditiously. This is what Dr. Taylor says. It was if the minister was satisfied that it should be settled expeditiously. And it dictated that the tribunal could not make awards which were inconsistent with the national interest. This is what Dr. Taylor says. Law is always the creature of the dominant group in the society, and it is the instrument of the state. As such, the state's interest at times defined what public interest and national interest is. And it then comes into legislation. In simple language, it's designed to fulfill the goals of the government. Sorry. This place is cold. All right. So the act was intended to further the interest of, is not intended to further the interest of workers or employers in that matter. It is to make sure that government policy stand up to scrutiny. And I have to agree with Dr. Taylor with that. 86, back to work orders, being able to go to court for injunctions. That was another amendment. And the 2002 definition of worker. Now, the rationale for the 2010 amendment came out of this wonderful case. Crown against Ministry of Labor, IDT, Devon Barrett, et al. Ex parte the West Indies case, a watershed case. And essentially, what the Chief Justice said was that the statute, the LRIDA, its ethos, what it was brought in to do was to keep industrial peace. The scheme of the act is to have industrial peace. And the Chief Justice said the minister is not authorized to act with complete freedom. His powers are governed by the scheme of the act. So the short version of the story is that if your one little dispute couldn't pop down the place, the minister should not and did not have the authority to refer a matter to the tribunal. And before that, regularly, if we go back to the IDT awards, one people were going to the tribunal, and with the West Indies case, that stopped BRAPS. And it stayed that way until we got to 2010. And what we saw, many persons face practical barriers. They had limited access. So unless you had the capacity to rally people, to make there be a lack of industrial peace, your matter could not get referred. They had to then, mostly then, be reliant on the unions. Individual grievances didn't get going anywhere. And that created concerns about fairness, accessibility, equality of treatment. And the ILO consistently were complaining about Jamaica and the reports that this was a problem. So, 2010 amendment, this is the timeline, not going to stay long on it. And so, individual workers, like unionized members, could then access the IDT, but not all matters. Disputes of rights. Rights disputes only. What you're seeing on that side is the provision that was put into the act to allow non-unionized workers. It says in the case of workers who are not members of a trade union having bargaining rights, being a dispute related to physical conditions of work, termination or suspension of employment, and matters affecting rights, duties of the employer. Technically, and I'm going to go out on a limb here, if a right is a maternity leave, for maternity leave, arguably, that's a right that could be able to be referred. I'm not hearing that. I'm going out on the limb. That's just me. We're not seeing those. We are seeing the disputes in respect of termination for the most part. That's what we see. Because that's the one that hits the hardest. The 2010 amendments therefore represented greater employee autonomy in pursuing their disputes. Again, may I get in trouble? What it means is that my union friends, and I love them, they are having some challenges, I would think, with 2010. In some of them, because some of them have had, prolific lives at the IDT as consultants. No problem. But it also shows the benefits of unionization. Why do I say that? It means that you have this collective group of people who are sitting down, hands in hands, knowing that they can't afford the place to pop down, and they sit down and find creative solutions to solve the problems. So that is why you don't have to have people come into the IDT, because they have a mechanism to work this through. And most times it works. So, what are the implications of the LRIDA amendment? Seismic shift in our industrial relations landscape. Fundamentally change dispute dynamics, empowering non-unionized workers since the significant reduction of unionization. We don't have any empirical data, but we can tell it's not as much as it used to be. Yes. And this impacts labor advocacy, policy focus, employer and employee dynamics, and recognizes the need for enhanced protection for that growing number of people. The 2010 amendment did not replace the original structure. The IDT is still the place to be. There are still collective bargaining mechanisms that were produced by that act. And the role of trade unions still remains. But what it did was to layer on the individual protections. So, 16 years later, as I come down, has the 2010 amendment improved fairness, equity in labor relations? What do you think? If you have a vast majority of persons who normally could not get access and now have access, isn't it that there is an improvement if those persons would not normally have been treated fairly on the ground? It's arguable. The positive effects, there's improved access, greater protection for vulnerable workers, reduced dependence on union intervention. Not that I'm licking my union friends, but if you don't have bargaining rights in a place, you can't get it. Simple. And there's recognition of workplace dignity and employee voice. What are the challenges? I'll talk the things. You see that 2013 thing to 2025 thing? What happened to those workers? Where were they when the IDT made an award and they couldn't see the fruits of that until the white man tell them so? That's a direct quote. Cost and procedural complexity. Because make no mistake about it, my colleagues, many of us, are venturing over there. And the IDT was not designed for black letter law. Juridification, continuing incursion, and it must be because it's a law, it has to be interpreted. But the complexities have created challenges. And these are my last two slides. From 2010, look at the trajectory. 24, and of course there were none. So coming down from the implementation, do you see the movement in terms of who is going where? From non-unionized to unionized. Let me give it a different iteration. The darker bars are unionized. The lighter bars are non-unionized. I say there has been something, but it is not to be dealt with openly. It is not to be dealt with just on the face of it. It has created more challenges. And that is why I believe a symposium like this is important. I want to hear from all those who are going to come and speak later, what other amendments I want to be and will be in those discussions about how do we change. And this is the last thing I'm going to say. Let me just get it up. Lord Wedderburn, in the book, Industrial Relations and the Courts, the Judge's Response to Employment Rights in Britain, a book in 1991, said something very important. He said, even as we look to change, and it is important, we should be careful that we do not wrench at a stroke into a new pattern a law to change its organic historical relationship with industrial relations. Let us make haste with a little slow pace. Let us make haste slowly. It's necessary, but let us don't throw out the baby and the bathwater. That's it for me.
Okay, we'd like to thank all panelists for their thought-provoking presentations, and now we will invite questions from the crowd.
Hello. Am I recognized, Chairman? Or somebody before me? Oh.
Yeah, reacting to Lambert's intervention on the question of interest. That is one constraint, but I think a far greater one is the reluctance of the tribunal to recognize that a worker, whether through the union or individually, that a matter is referred. The question of costs. There's a considerable cost for a worker to access the tribunal, which although the award can be made in the discretion of the tribunal, it has been reluctant to speak to the issue of cost.
John, can I just respond to that? Wayne will tell you it's a two-way stream. Because essentially, if the case goes against a worker, will cost be awarded to the employer against the worker? So it's a balancing act. I mean, I'd certainly love, given my own record, to have gotten costs. But, but the reality is I have to see it that, because an issue that has come up, is cost a one-way thing? Because Carla is right. It was meant to be the quick go for the worker. Worker could represent himself. I mean, what if a worker come and represent his or herself, fails, lose, and then cost awarded to them? So I think the people in 76, 74, 75 considered that and felt, let's balance it out. But I understand the point you're making.
The issue, though, with all due respect, is that the tribunal award does not say it has to be only what the person lost in terms of the employment issue. It says the tribunal may make such award as it thinks fit. So if you wish to use that, it could go either way. You can award for the worker in some instances, and where it is fair that the employer, who is far more equipped, right, to deal with the question of their own costs.
John, to be fair to the IDT, I'm aware of at least one case where a state agency, and the chairman was Mr. Wright, I think he was a QC, but he found a way and he said he gave a compensation of a certain figure, I think it's a 6-digit figure or so, but he gave compensation as part of it. But I'm sure, I'm prepared to tell you that there are people in this room, if the tribunal and Mr. Miller or anybody else go and award costs, there's another cost station down at King Street, on both sides of King Street. And if it fails on both sides of King Street, it is going to London.
A quick response, Sir Junior. So happy to see you. And many of you may not know that Sir John was a part of the tribunal in its early days. One of the things that I think we have to appreciate is that the tribunal no longer is practically operating in the way in which, based on my research, it was envisioned to operate. It no longer is just an avenue of settling disputes. Because of the nature of the various legal challenges and principles of law that have evolved by virtue of the various cases going to judicial review all the way up to the Privy Council, there are legal principles that guide, and the tribunal themselves must be guided by, because they don't want that they are going to have unsuccessful challenges. I'm talking the things, Mr. Miller, you never give me any message. To be open to judicial review. So when you get to the point that legal matters are being, having to be examined on a case, legal matters need lawyers. Lawyers get paid, GG. Right? And so the issue of cost. So the cost issue is no attorney that is going to come and spend 2-4 hours at the tribunal every day and prepare. That is places that they would be otherwise that they could send a bill to. So we have to appreciate, one, the tribunal has to be guided by the legal principles. Many of those legal principles, because of the composition of the tribunal, another area that people have not really touched at, in terms of having a legal person sitting on every panel, they now have to be guided. So in order for them to ensure that things are being done properly, the law has lawyers, and lawyers have to be paid. So the question of cost, sir, I think it's important, but I don't think that they can, without more, determine that they are going to add costs without, I think, provision that specifically says that. I mean, it can be so interpreted, but I think it would be better for have legal provisions that speak to the matter. I think that is in other jurisdictions as well. I'm sure when Her Honor speaks, she may speak to that later on this afternoon.
I just want to add one point to that. That remember that the awards can be challenged on a point of law. And one of the considerations that we always have to make is whether or not we are giving the party a Pyrrhic victory by overextending what we are doing. And so when we talk about costs, we may put cost in there and everything is thrown out. So the awards have to take into account, is it a fair award from our standpoint, so that we don't give whoever we are awarding a Pyrrhic victory. And that's very important.
I just wanted to, it's on? It's on? Yeah, I just want to say, with respect, I agree with Carla that if you're looking at issues of cost, you're talking about amending your legislation, then that should be considered. In terms of Trinidad and Tobago, we do not award cost, but the legislation says that cost can be given in exceptional circumstances. Now, the whole reason behind it is that the ordinary man, the ordinary union, the ordinary person should come to the court, have his matter heard without incurring any sort of cost, and be free to get his judgment delivered one way or the other. Now, I heard somebody spoke earlier about awards people have to pay taxes on awards. In our taxation laws, once there is an order from a court, whether it's for damages or whatever, it is exempt from taxation. You may want to look at your legislation, because if someone gets an award, why are they paying tax on an award? What we will pay tax if there is retrenchment and the figure is over $500,000, then you will come to pay tax and there is a reduced tax on that. But ordinarily, once there is an award for damages, you should not pay tax.
Hello. Testing. First, let me thank the tribunal for its kind invitation so that I can be here. I think I was around when the tribunal get started, and I certainly remember some of those meetings in Crossroads where the air condition wasn't working. But albeit we did got through, and you know, it's good to see and to hear what is happening in terms of the tribunal, the work it has done, and certainly will continue to do. Well, put it this way, I don't believe that something that is not broken should be fixed. And if the tribunal is doing a good job, then it should continue to do so. But the employer, they will tell you that the small business been having some issues as it relates to the question of procedure. And I heard the word procedure being mentioned earlier. You know, the question really is that procedure can be for big business and not for small business. And I hope my friend Mr. Chen is here listening. Right? A small business starts small and get big. And, you know, you couldn't have a separation, as was mentioned previously, for small business. And then the court. Basically, what the tribunal does in terms of procedure, right, is really what the court, Mr. Sykes and the others in the court system do. I mean, if you don't instruct the jury properly, then procedurally you're going to have, the man is going to get off of whatever charge. So the tribunal, and then we'll have to understand that the tribunal is more or less supervised in a way, because its awards are taken to the court. They are taken to the Privy Council. And my information is that the vast majority of the awards, you know, pass the test, not in only our local courts, but at the Privy Council. So it's really at a level of supervision to show the worth of the tribunal. In terms of the Labor Relations and Industrial Dispute Act, let me say it is perhaps the finest piece of legislation that we have had in this country for a very long time. Nothing is wrong with the legislation, although I'd love to see Section 12A, I think, the one that deals with the fixed-term contract. I'd like to see some changes there. And I just want to be clear, because fixed-term contracts are a legal instrument. But it is being abused in Jamaica. There's no question that it's been abused. And therefore, I think Parliament has a responsibility, and not necessarily the tribunal. Parliament has a responsibility to fix that. And I do hope that our trade union brothers in the Parliament will deal with that. So the list that Lambert spoke to in terms of amendments, I support that. The contract work, that has to be done. The issue of award of interest, in fact, the private power matter, I just want to say, and I see Mr. Goff here, that will be going to the court because we have no choice because we think it's unfair from 2013 to be paying the workers the same thing, the same amount of money that they would get in 2013. So this is not an announcement, but that is going to the court, Supreme Court. The ex-parte arrangement here, I think that should be amended. I think it's a contradiction. I think that should be dealt with. And finally, I believe that the national interest must be something that you cannot take the worker out of that picture. The national interest can be a situation where Separate have a strike or Windalco have a strike and that matter is rushed to the tribunal because of national interest. The national interest is yet to be defined, and I would believe that in the interest of justice, Parliament should do some work in that direction. Thank you.
Afternoon, everyone. I'd just like to announce that Dr. Taylor was able to... One question. No. I can't one question. No. Okay. I'd like to announce welcome Dr. Taylor. Unfortunately, I have been informed that we have to cut the session now due to time constraints, but I'm pretty sure the panelists would welcome some further discussions at lunch. So I'm sure they would answer your questions there. So once again, I'd just like to thank everyone for their contributions.
Yeah, before you go for lunch, I'd like to recognize Mr. Gregory Reed. Gregory, who has been around advocating for the employers from Slipe Road, as Vincent Morrison just said, from Slipe Road. And there are just a few of us left who have been through every location that the IDT have been. In fact, I've been in every room that the IDT has litigated matters, whether Slipe Road, Intercon Hotel, which is now the Rock, or Ellis May Road, except for the new one that Mr. Miller just opened on the downstairs floor.
Okay. Thank you very much, Senator. Look, we it's now about 1:20, thereabouts, 1:40, 1:15 as a matter of fact by my watch. I understand we can have 45 minutes for lunch, if you don't mind. We would be very grateful if you could be back at around 2 o'clock and for the next session, all right? And your burning questions can be taken some of those questions can be taken in subsequent sessions, okay? All right, good. I understand lunch is ready.